Article 2101. The pledgor has the same responsibility as a bailor in comitatum in the case under Article 1951. N. Article 2102. If the pledge earns or produces fruits, income, dividends, or interests, the creditor shall compensate what he receives with those which are owing him, but if none are owing him, or insofar as the amount may exceed that which is due, he shall apply it to the principal, unless there is a stipulation to the contrary. The pledge shall extend to the interest and earnings of the right pledged. In case of a pledge of animals, their offspring shall pertain to the pledgor or owner of animals pledged, but shall be subject to the pledge, if there is no stipulation to the contrary. 1868a. Article 2103. Unless the thing pledged is expropriated, the debtor continues to be the owner thereof. Nevertheless, the creditor may bring the actions which pertain to the owner of the thing pledged in order to recover it from, or defend it against a third person. 1869. Article 2104. The creditor cannot use the thing pledged without the authority of the owner, and if he should do so, or should misuse the thing in any other way, the owner may ask that it be judicially or extrajudicially deposited. When the preservation of the thing pledged requires its use, it must be used by the creditor, but only for that purpose. 1870a. Article 2105. The debtor cannot ask for the return of the thing pledged against the will of the creditor, unless and until he has paid the debt and its interest, with expenses in a proper case. 1871. Article 2106. If through the negligence or willful act of the pledgee, the thing pledged is in danger of being lost, or impaired, the pledgor may require that it be deposited with a third person. N. Article 2107. If there are reasonable grounds to fear the destruction or impairment of the thing pledged, without the fault of the pledgee, the pledgor may demand the return of the thing, upon offering another thing in pledge, provided the latter is of the same kind as the former and not of inferior quality, and without prejudice to the right of the pledgee under the provisions of the following article. The pledgee is bound to advise the pledgor, without delay, of any danger to the thing pledged. N. Article 2108. If, without the fault of the pledgee, there is danger of destruction, impairment, or diminution in value of the thing pledged, he may cause the same to be sold at a public sale. The proceeds of the auction shall be a security for the principal obligation in the same manner as the thing originally pledged. N. Article 2109. If the creditor is deceived on the substance or quality of the thing pledged, he may either claim another thing in its stead, or demand immediate payment of the principal obligation. N. Article 2110. If the thing pledged is returned by the pledgee to the pledgor or owner, the pledge is extinguished. Any stipulation to the contrary shall be void. If subsequent to the perfection of the pledge, the thing is in the possession of the pledgor or owner, there is a prima facie presumption that the same has been returned by the pledgee. This same presumption exists if the thing pledged is in the possession of a third person who has received it from the pledgor or owner after the constitution of the pledge. N. Article 2111. A statement in writing by the pledgee that he renounces or abandons the pledge is sufficient to extinguish the pledge. For this purpose, neither the acceptance by the pledgor or owner, nor the return of the thing pledged is necessary, the pledgee becoming a depositary. N. Article 2112. The creditor to whom the credit has not been satisfied in due time may proceed before a notary public to the sale of the thing pledged. This sale shall be made at a public auction. and with notification to the debtor and the owner of the thing pledged. In a proper case, stating the amount for which the public sale is to be held. If at the first auction the thing is not sold, a second one, with the same formalities shall be held, and if at the second auction there is no sale either, the creditor may appropriate the thing pledged. In this case he shall be obliged to give an acquittance for his entire claim. 1872a. Article 2113. At the public auction, the pledgor or owner may bid. He shall, moreover, have a better right if he should offer the same terms as the highest bidder. The pledgee may also bid, but his offer shall not be valid if he is the only bidder. N. Article 2114. All bids at the public auction shall offer to pay the purchase price at once. If any other bid is accepted, the pledgee is deemed to have been received the purchase price, as far as the pledgor or owner is concerned. N. Article 2115. The sale of the thing pledged shall extinguish the principal obligation, whether or not the proceeds of the sale are equal to the amount of the principal obligation, interest and expenses in a proper case. If the price of the sale is more than said amount, the debtor shall not be entitled to the excess, unless it is otherwise agreed. If the price of the sale is less, neither shall the creditor be entitled to recover the deficiency, notwithstanding any stipulation to the contrary. N. Article 2116. After the public auction, the pledgee shall promptly advise the pledgor or owner of the result thereof. N. Article 2117. Any third person who has any right in or to the thing pledged may satisfy the principal obligation as soon as the latter becomes due and demandable. N. Article 2118. If a credit which has been pledged becomes due before it is redeemed, the pledgee may collect and receive the amount due. He shall apply the same to the payment of his claim, and deliver the surplus, should there be any, to the pledgor. N. Article 2119. If two or more things are pledged, the pledgee may choose which he will cause to be sold, unless there is a stipulation to the contrary. He may demand the sale of only as many of the things as are necessary for the payment of the debt. N. Article 2120. If a third party secures an obligation by pledging his own movable property under the provisions of Article 2085, he shall have the same rights as a guarantor under Articles 2066 to 2070 and Articles 2077 to 2081. He is not prejudiced by any waiver of defense by the principal obliger. N. Article 2121. Pledges created by operation of law, such as those referred to in Articles 546, 1731, and 1994, are governed by the foregoing articles on the possession, care and sale of the thing as well as on the termination of the pledge. However, after payment of the debt and expenses, the remainder of the price of the sale shall be delivered to the obliger. N. Article 2122. A thing under a pledge by operation of law may be sold only after demand of the amount for which the thing is retained. The public auction shall take place within 1 month after such demand. If without just grounds, the creditor does not cause the public sale to be held within such period, the debtor may require the return of the thing. N. Article 2123. With regard to pawnshops or other establishments which are engaged in making loans secured by pledges, the special laws and regulations concerning them shall be observed, and subsidiarily the provisions of this title. 1873a. Chapter 3. Mortgage. Article 2124. Only the following property may be the object of a contract of mortgage: 1. Immovables. 2. Alienable real rights in accordance with the laws imposed upon immovables. Nevertheless, movables may be the object of a chattel mortgage. 1874a. Article 2125. In addition to the requisites stated in Article 2085, it is indispensable, in order that a mortgage may be validly constituted, that the document in which it appears be recorded in the Registry of Property. If the instrument is not recorded, the mortgage is nevertheless binding between the parties. The persons in whose favor the law establishes a mortgage have no other right than to demand the execution and the recording of the document in which the mortgage is formalized. 1875a. Article 2126. The mortgage directly and immediately subjects the property upon which it is imposed, whoever the possessor may be, to the fulfillment of the obligation for whose security it was constituted. 1876. Article 2127. The mortgage extends to the natural accessions, to the improvements, growing fruits, and the rents or income not yet received when the obligation becomes due, and to the amount of the indemnity granted or owing to the proprietor from the insurers of the property mortgaged, or in virtue of expropriation for public use, with the declarations, amplifications and limitations established by law, whether the estate remains in the possession of the mortgagor, or it passes into the hands of a third person. 1877. Article 2128. The mortgage credit may be alienated or assigned to a third person, in whole or in part, with the formalities required by law. 1878. Article 2129. The creditor may claim from a third person in possession of the mortgaged property the payment of the part of the credit secured by the property which said third person possesses, in the terms and with the formalities which the law establishes. 1879. Article 2130. A stipulation forbidding the owner from alienating the immovable mortgaged shall be void. N. Article 2131. The form, extent and consequences of a mortgage, both as to its constitution, modification and extinguishment, and as to other matters not included in this chapter, shall be governed by the provisions of the mortgage law and of the land registration law. 1880a. Chapter 4. Anti-Cressis. Article 2132. By the contract of anti-cressis the creditor acquires the right to receive the fruits of an immovable of his debtor, with the obligation to apply them to the payment of the interest, if owing, and thereafter to the principal of his credit. 1881. Article 2133. The actual market value of the fruits at the time of the application thereof to the interest and principal shall be the measure of such application. N. Article 2134. The amount of the principal and of the interest shall be specified in writing. Otherwise, the contract of anti-cressis shall be void. N. Article 2135. The creditor, unless there is a stipulation to the contrary, is obliged to pay the taxes and charges upon the estate. He is also bound to bear the expenses necessary for its preservation and repair. The sums spent for the purposes stated in this article shall be deducted from the fruits. 1882. Article 2136. The debtor cannot reacquire the enjoyment of the immovable without first having totally paid what he owes the creditor. But the latter, in order to exempt himself from the obligations imposed upon him by the preceding article, may always compel the debtor to enter again upon the enjoyment of the property, except when there is a stipulation to the contrary. 1883. Article 2137. The creditor does not acquire the ownership of the real estate for non-payment of the debt within the period agreed upon. Every stipulation to the contrary shall be void. But the creditor may petition the court for the payment of the debt or the sale of the real property. In this case, the rules of court on the foreclosure of mortgages shall apply. 1884a. Article 2138. The contracting parties may stipulate that the interest upon the debt be compensated with the fruits of the property, which is the object of the anti-crisis, provided that if the value of the fruits should exceed the amount of interest allowed by the laws against usury, the excess shall be applied to the principal. 1885a. Article 2139. The last paragraph of Article 2085 and Articles 2089 to 2091 are applicable to this contract. 1886a. Chapter 5. Chattel mortgage. Article 2140. By a chattel mortgage, personal property is recorded in the chattel mortgage register as a security for the performance of an obligation. If the movable, instead of being recorded, is delivered to the creditor or a third person, the contract is a pledge and not a chattel mortgage. N. Article 2141. The provisions of this code on pledge, insofar as they are not in conflict with the chattel mortgage law, shall be applicable to chattel mortgages. N. Title 17. Extra-contractual obligations. Chapter 1. Quasi-contracts. Article 2142. Certain lawful, voluntary and unilateral acts give rise to the juridical relation of quasi-contract to the end that no one shall be unjustly enriched or benefited at the expense of another. N. Article 2143. The provisions for quasi-contracts in this chapter do not exclude other quasi-contracts which may come within the purview of the preceding article. N. Section 1. Negotiorum gestia. Article 2144. Whoever voluntarily takes charge of the agency or management of the business or property of another, without any power from the latter, is obliged to continue the same until the termination of the affair and its incidents, or to require the person concerned to substitute him, if the owner is in a position to do so. This juridical relation does not arise in either of these instances. 1. When the property or business is not neglected or abandoned. 2. If in fact the manager has been tacitly authorized by the owner. In the first case, the provisions of Articles 1317, 1403, No. 1, and 1404 regarding unauthorized contracts shall govern. In the second case, the rules on agency in Title X of this book shall be applicable. 1888a. Article 2145. The officious manager shall perform his duties with all the diligence of a good father of a family, and pay the damages which through his fault or negligence may be suffered by the owner of the property or business under management. The courts may, however, increase or moderate the indemnity according to the circumstances of each case. 1889a. Article 2146. If the officious manager delegates to another person all or some of his duties, he shall be liable for the acts of the delegate, without prejudice to the direct obligation of the latter toward the owner of the business. The responsibility of two or more officious managers shall be solidary, unless the management was assumed to save the thing or business from imminent danger. 1890a. Article 2147. The officious manager shall be liable for any fortuitous event. 1. If he undertakes risky operations which the owner was not accustomed to embark upon. 2. If he has preferred his own interest to that of the owner. 3. If he fails to return the property or business after demand by the owner. 4. If he assumed the management in bad faith. 1891a. Article 2148. Except when the management was assumed to save property or business from imminent danger, the officious manager shall be liable for fortuitous events. 1. If he is manifestly unfit to carry on the management. 2. If by his intervention he prevented a more competent person from taking up the management. N. Article 2149. The ratification of the management by the owner of the business produces the effects of an express agency, even if the business may not have been successful. 1892a. Article 2150. Although the officious management may not have been expressly ratified, the owner of the property or business who enjoys the advantages of the same shall be liable for obligations incurred in his interest, and shall reimburse the officious manager for the necessary and useful expenses and for the damages which the latter may have suffered in the performance of his duties. The same obligation shall be incumbent upon him when the management had for its purpose the prevention of an imminent and manifest loss, although no benefit may have been derived. 1893. Article 2151. Even though the owner did not derive any benefit and there has been no imminent and manifest danger to the property or business, the owner is liable as under the first paragraph of the preceding article, provided 1. The officious manager has acted in good faith, and 2. The property or business is intact, ready to be returned to the owner. N. Article 2152. The officious manager is personally liable for contracts which he has entered into with third persons, even though he acted in the name of the owner, and there shall be no right of action between the owner and third persons. These provisions shall not apply. 1. If the owner has expressly or tacitly ratified the management, or 2. When the contract refers to things pertaining to the owner of the business. N. Article 2153. The management is extinguished. 1. When the owner repudiates it or puts an end thereto. 2. When the officious manager withdraws from the management, subject to the provisions of Article 2144. 3. By the death, civil interdiction, insanity or insolvency of the owner or the officious manager. N. Section 2. Solutio indebiti. Article 2154. If something is received when there is no right to demand it, and it was unduly delivered through mistake, the obligation to return it arises. 1895. Article 2155. Payment by reason of a mistake in the construction or application of a doubtful or difficult question of law may come within the scope of the preceding article. N. Article 2156. If the payer was in doubt whether the debt was due, he may recover if he proves that it was not due. N. Article 2157. The responsibility of two or more payees, when there has been payment of what is not due, is solidary. N. Article 2158. When the property delivered or money paid belongs to a third person, the payee shall comply with the provisions of Article 1984. N. Article 2159. Whoever in bad faith accepts an undue payment shall pay legal interest if a sum of money is involved, or shall be liable for fruits received or which should have been received if the thing produces fruits. He shall furthermore be answerable for any loss or impairment of the thing from any cause, and for damages to the person who delivered the thing, until it is recovered. 1896a. Article 2160. He who in good faith accepts an undue payment of a thing certain and determinate, shall only be responsible for the impairment or loss of the same or its accessories and accessions insofar as he has thereby been benefited. If he has alienated it, he shall return the price, or assign the action to collect the sum. 1897. Article 2161. As regards the reimbursement for improvements and expenses incurred by him who unduly received the thing, the provisions of Title V of Book 2 shall govern. 1898. Article 2162. He shall be exempt from the obligation to restore who, believing in good faith that the payment was being made of a legitimate and subsisting claim, destroyed the document, or allowed the action to prescribe, or gave up the pledges, or cancelled the guarantees for his right. He who paid unduly may proceed only against the true debtor or the guarantors with regard to whom the action is still effective. 1899. Article 2163. It is presumed that there was a mistake in the payment if something which had never been due or had already been paid was delivered, but he from whom the return is claimed may prove that the delivery was made out of liberality or for any other just cause. 1901. Section 3. Other quasi-contracts *. Article 2164. When, without the knowledge of the person obliged to give support, it is given by a stranger, the latter shall have a right to claim the same from the former, unless it appears that he gave it out of piety and without intention of being repaid. 1894a. Article 2165. When funeral expenses are borne by a third person, without the knowledge of those relatives who are obliged to give support to the deceased, said relatives shall reimburse the third person, should the latter claim reimbursement. 1894a. Article 2166. When the person obliged to support an orphan, or an insane or other indigent person unjustly refuses to give support to the latter, any third person may furnish support to the needy individual, with right of reimbursement from the person obliged to give support. The provisions of this article apply when the father or mother of a child under 18 years of age unjustly refuses to support him. Article 2167. When through an accident or other cause a person is injured or becomes seriously ill, and he is treated or helped while he is not in a condition to give consent to a contract, he shall be liable to pay for the services of the physician or other person aiding him, unless the service has been rendered out of pure generosity. Article 2168. When during a fire, flood, storm, or other calamity, property is saved from destruction by another person without the knowledge of the owner, the latter is bound to pay the former just compensation. Article 2169. When the government, upon the failure of any person to comply with health or safety regulations concerning property, undertakes to do the necessary work, even over his objection, he shall be liable to pay the expenses. Article 2170. When by accident or other fortuitous event, movables separately pertaining to two or more persons are commingled or confused, the rules on co-ownership shall be applicable. Article 2171. The rights and obligations of the finder of lost personal property shall be governed by Articles 719 and 720. Article 2172. The right of every possessor in good faith to reimbursement for necessary and useful expenses is governed by Article 546. Article 2173. When a third person, without the knowledge of the debtor, pays the debt, the rights of the former are governed by Articles 1236 and 1237. Article 2174. When in a small community a majority of the inhabitants of age decide upon a measure for protection against lawlessness, fire, flood, storm or other calamity, anyone who objects to the plan and refuses to contribute to the expenses but is benefited by the project as executed shall be liable to pay his share of said expenses. Article 2175. Any person who is constrained to pay the taxes of another shall be entitled to reimbursement from the latter. Chapter 2. Quasi-delicts. Article 2176. Whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict, and is governed by the provisions of this chapter. 1902a. Article 2177. Responsibility for fault or negligence under the preceding article is entirely separate and distinct from the civil liability arising from negligence under the Penal Code. But the plaintiff cannot recover damages twice for the same act or omission of the defendant. N. Article 2178. The provisions of Articles 1172 to 1174 are also applicable to a quasi-delict. N. Article 2179. When the plaintiff's own negligence was the immediate and proximate cause of his injury, he cannot recover damages. But if his negligence was only contributory, the immediate and proximate cause of the injury being the defendant's lack of due care, the plaintiff may recover damages, but the courts shall mitigate the damages to be awarded. N. Article 2180. The obligation imposed by Article 2176 is demandable not only for one's own acts or omissions, but also for those of persons for whom one is responsible. The father and, in case of his death or incapacity, the mother, are responsible for the damages caused by the minor children who live in their company. Guardians are liable for damages caused by the minors or incapacitated persons who are under their authority and live in their company. The owners and managers of an establishment or enterprise are likewise responsible for damages caused by their employees in the service of the branches in which the latter are employed or on the occasion of their functions. Employers shall be liable for the damages caused by their employees and household helpers acting within the scope of their assigned tasks, even though the former are not engaged in any business or industry. The state is responsible in like manner when it acts through a special agent, but not when the damage has been caused by the official to whom the task done properly pertains, in which case what is provided in Article 2176 shall be applicable. Lastly, teachers or heads of establishments of arts and trades shall be liable for damages caused by their pupils and students or apprentices, so long as they remain in their custody. The responsibility treated of in this article shall cease when the persons herein mentioned prove that they observed all the diligence of a good father of a family to prevent damage. 1903a. Article 2181. Whoever pays for the damage caused by his dependents or employees may recover from the latter what he has paid or delivered in satisfaction of the claim. 1904. Article 2182. If the minor or insane person causing damage has no parents or guardian, the minor or insane person shall be answerable with his own property in an action against him where a guardian ad litem shall be appointed. N. Article 2183. The possessor of an animal or whoever may make use of the same is responsible for the damage which it may cause, although it may escape or be lost. This responsibility shall cease only in case the damage should come from force majeure, or from the fault of the person who has suffered damage. 1905. Article 2184. In motor vehicle mishaps, the owner is solidarily liable with his driver, if the former, who was in the vehicle, could have, by the use of the due diligence, prevented the misfortune. It is disputably presumed that a driver was negligent, if he had been found guilty of reckless driving or violating traffic regulations at least twice within the next preceding 2 months. If the owner was not in the motor vehicle, the provisions of Article 2180 are applicable. N. Article 2185. Unless there is proof to the contrary, it is presumed that a person driving a motor vehicle has been negligent if at the time of the mishap, he was violating any traffic regulation. N. Article 2186. Every owner of a motor vehicle shall file with the proper government office a bond executed by a government-controlled corporation or office, to answer for damages to third persons. The amount of the bond and other terms shall be fixed by the competent public official. N. Article 2187. Manufacturers and processors of foodstuffs, drinks, toilet articles and similar goods shall be liable for death or injuries caused by any noxious or harmful substances used, although no contractual relation exists between them and the consumers. N. Article 2188. There is prima facie presumption of negligence on the part of the defendant if the death or injury results from his possession of dangerous weapons or substances, such as firearms and poison, except when the possession or use thereof is indispensable in his occupation or business. N. Article 2189. Provinces, cities and municipalities shall be liable for damages for the death of, or injuries suffered by, any person by reason of the defective condition of roads, streets, bridges, public buildings, and other public works under their control or supervision. N. Article 2190. The proprietor of a building or structure is responsible for the damages resulting from its total or partial collapse, if it should be due to the lack of necessary repairs. 1907. Article 2191. Proprietors shall also be responsible for damages caused 1. By the explosion of machinery which has not been taken care of with due diligence, and the inflammation of explosive substances which have not been kept in a safe and adequate place. 2. By excessive smoke, which may be harmful to persons or property. 3. By the falling of trees situated at or near highways or lanes, if not caused by force majeure. 4. By emanations from tubes, canals, sewers or deposits of infectious matter, constructed without precautions suitable to the place. 1908. Article 2192. If damage referred to in the two preceding articles should be the result of any defect in the construction mentioned in Article 1723, the third person suffering damages may proceed only against the engineer or architect or contractor in accordance with said article, within the period therein fixed. 1909. Article 2193. The head of a family that lives in a building or a part thereof is responsible for damages caused by things thrown or falling from the same. 1910. Article 2194. The responsibility of two or more persons who are liable for quasi-delict is solidary. N. Title 18. Damages 1. Chapter 1. General Provisions. Article 2195. The provisions of this title shall be respectively applicable to all obligations mentioned in Article 1157. Article 2196. The rules under this title are without prejudice to special provisions on damages formulated elsewhere in this code. Compensation for workmen and other employees in case of death, injury or illness is regulated by special laws. Rules governing damages laid down in other laws shall be observed insofar as they are not in conflict with this code. Article 2197. Damages may be 1. Actual or compensatory. 2. Moral. 3. Nominal. 4. Temperate or moderate. 5. Liquidated, or 6. Exemplary or corrective. Article 2198. The principles of the general law on damages are hereby adopted insofar as they are not inconsistent with this code. Chapter 2. Actual or compensatory damages. Article 2199. Except as provided by law or by stipulation, one is entitled to an adequate compensation only for such pecuniary loss suffered by him as he has duly proved. Such compensation is referred to as actual or compensatory damages. Article 2200. Indemnification for damages shall comprehend not only the value of the loss suffered, but also that of the profits which the obligee failed to obtain.